Joining us now is Kenji Yoshino, who's a professor of constitutional law at New York University Law School. Mr. Yoshino, thank you for being with us tonight. Weigh this, because some people are all about the leak, and most people, especially those of us who aren't lawyers, are all about the underlying law and what's going to happen to abortion rights and perhaps other rights going forward. What's the relative importance or connection between the two?
I think the latter is far more important, and you're absolutely right, Ali, to focus on it. But they are both important. So just to get the leak out of the way, I want to suggest that this dropping of opinion is one thing, but the steady kind of drip, drip, drip that suggests that there are embedded sources inside of the Supreme Court is really, really troubling. I just want to remind everyone that we think of the Supreme Court as this invulnerable institution, but that wasn't always the case. If we go back to the founding, we see that the court was in fact a very fragile institution, and that the Supreme Court justices would often leave the court in order to be justices on state Supreme Courts or to be foreign diplomats, something that I think would be quite unimaginable today. So over time, it's built up its mystique and its prestige, but a large part of that has to do with its procedural regularity and its confidentiality. And the more that gets breached, as these leaks suggest that they are being breached, the more the legitimacy of the court is going to take a hit. So one thing that I want to look for, Ali, is in these future big ticket cases, are we to expect similar decision drops of draft opinions prior to the issuance of the opinion itself?
It's kind of interesting, though, if you do that. In fact, you had suggested that if you do that, it feels almost like the issuance of a regulation where draft regulations are subjected to a notice period and comment procedures before they become final. That's not how the Supreme Court rolls. It's how my city council rolls. It's how a lot of states roll when they've got a new law to put out there. You suggest that that would be a sea change, that hey, they float something out there to see how it goes and wait to get feedback before their final decision.
Absolutely. The Supreme Court has sedulously guarded its confidentiality. And as Justice Ginsburg used to say, those who know don't talk, and those who talk don't know. So as Adam Liptak said in an article that he published just a couple of hours ago in the New York Times, the Supreme Court is now starting to look like the other branches of government, and it's starting to look comparably leaky in ways that can only damage its legitimacy going forward.
All right, so let's assume that there are a lot of Americans who think the legitimacy is damaged, either because of the politicization of the court or the leaks or things like that. What's the fix? And in attempting to fix it, do you risk more damage?
Well, I think the fix is really, first of all, to think about how to stop leaking, right? But I think more deeply and more importantly, as you gestured at the top of this conversation, it's really to make sure that we keep our eyes on the prize and on what's important. Because when I think about those two threats to the legitimacy of the court, there are really two of them. One is the leakiness. The other one is the substance of this draft opinion itself. And as threatening as these leaks are, they are as nothing compared to the trampling of precedent and the trampling of rights that are embodied in the draft opinion. So my real concern about the leaks is that I'm quite ambivalent about talking about them, even though they are important. Mm-hmm. And I'm ambivalent about them because every single minute that we spend talking about the leaks is a minute that we don't talk about the horror of the substance of the opinion itself.
Well, then let's do that, because when one is reading the Constitution, one comes away with two things. There's a lot of remarkably interesting stuff in the Constitution, and it feels a little removed from our daily lives because it doesn't enumerate rights that we know to be ours and we know to be protected, but they're not written into the Constitution. Alito made a reference to the fact that Roe's not secure because abortion is not an enumerated right in the Constitution. That a lot of people have looked at that, a lot of smart people like you have looked at that and said, that argument doesn't hold a lot of water.
Right. So first of all, we all know that there are unenumerated rights in the Constitution, right? So the right to marry, the right to vote, the right to travel across state lines, none of these are enumerated in the Constitution. In fact, the Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others held by the people. So there's text in the Constitution that tells us that there are non-textual rights in the Constitution, if you will. So the question is not whether they're unenumerated rights, but which ones are going to be protected. And the devastating impact of this opinion is that it articulates a test that endangers so many of the personal rights that have been assured over the past 5 decades or so since the Griswold versus Connecticut case of 1965. So I, again, want to focus us on the abortion right. The most execrable thing that the opinion did was that it bombed us back to a 1970s vision of what women's autonomy and equality mean in this country. And that is a horrifying aspect of the opinion. And all of us who consider ourselves allies to women should actually be extremely concerned about that, to put it mildly. But I also want to say that the additional terrible part of this opinion is that it said the only unenumerated rights that we're going to protect are those that are, quote unquote, deeply rooted in this nation's history and traditions. And if we apply that test, right, which despite the court's claims to the contrary, sort of ignores prior precedent, like the Obergefell case, what we would get rid of are things like the right to same-sex marriage, the right to privacy in our sexual conduct, the right to contraception, even the right to interracial marriage. So we should all be sounding the alarm bell. You start to see, Ali, why I'm a little less concerned about the leak and more concerned about the substance of the opinion. Because even if, in response to this leak, let's say best case scenario, they change the opinion, they water it down, right, and they come up with a much more anodyne version of what they wrote in this draft opinion, they still cannot sort of unring the bell or unpoison the well. We now know that there are at least 5 justices on this Supreme Court who are willing to completely trample on the personal rights that we all depend on for a functioning modern society.
You've made your case well, Professor Yoshino. We appreciate it. Kenji Yoshino is a professor of constitutional law at New York University Law School, and we appreciate your time tonight.